Hello, everybody. Teachblade here, blog author of Paralegal Brains blog. Wanted to talk a few minutes with you about a family law matter. If you are a seasoned paralegal who's an independent contractor, there are a lot of young lawyers, say between 0 years and 5 years work experience, who are very interested in seasoned paralegals who know the procedural process, who know how to get the paperwork through the court, and in the process help build up databases of pleadings and forms that can be used later. And once that has occurred, that seasoned paralegal then concludes his or her contract with the particular lawyer or law firm, and someone else that has less experience can then come in and reduplicate the procedure ad infinitum. So it works out as a win-win situation for a lot of young law firms as well as seasoned paralegals, and something to think about. Anyway, I was approached regarding my take on a particular fact pattern and wanted to share it with you. It involves a family of teenagers. One is a male child and the other is a female, and the mother resides with the two children out of state in the Midwest, and the father resides here in the state of California. The 16-year-old is very desirous of living with the father after 10 years of being with his mother, and there's a very compelling reason for that, and that is that he's 16. He wants to learn about manhood. He wants his father to take him to manhood. Very compelling reason that the court will consider, and because he is the age of 16, he's able to testify. I should say, speak to the mediator and speak to the court if need be regarding what his desire is as he expressed it to his father, and as he will express it to the court. There's a case called Montenegro versus Diaz, which is a seminal case in the California courts making a decision regarding custody that's based on one or two standards. One is the best interest of the child, the other is a changed circumstance standard. The best interest of the child standard is the first consideration when the court makes an initial custody order. So the question becomes, in analyzing where the case needs to go from here, the first thing I had to do was to make a determination as to whether or not the custody order was an initial custody order, or whether or not it was permanent, temporary or permanent. Well, after these many years, it's certainly permanent. But suffice it to say, if a custody order is initial, say like an initial OSC, where there's never been a court order before, and you come into court for the hearing, that court is going to make a temporary custody order before a custody order is later subsumed within a final judgment of dissolution of marriage. That initial custody order is based on an analysis of it's a two-pronged analysis. One, who is the primary care provider, and the conjunction and, which means both events must operate at the same time in order for the rule to be satisfied. Who is the primary care provider for the child, and who is the parent most likely to facilitate the parent-child relationship with the other parent? Those two questions must be answered by a judge in making a determination as to who is the proper parent to have primary physical custody of the child. It could be some type of a joint physical arrangement. That's fine. But if it became an issue of one or two parents because of, say, locale, as is this case, the court is going to make a determination on two things: who is the primary care provider, and who is the parent most likely to facilitate the parent-child relationship with the other parent. Once that order is in place and it's been working for years and it's been ongoing, any change of custody subsequent to that order becoming final, which this one was subsumed within the final judgment of dissolution of marriage. The court will consider a change of custody based on one standard only, and that is a changed circumstance standard. The original standard, which was the best interest of the child standard, was a consideration of both parents' history, where they worked, where they went to school, what they did, what they believed in, who their friends were. It was a consideration of both parents. But when there is a later OSC modification of the original order, that's a permanent order, and there has to be some type of changed circumstance that is detrimental to the minor child. The court is not concerned about the wants and desires of the parents. The court has a legal charge to do that which is in the best interest of the minor child. So here we have a 16-year-old who has expressed this desire. And why is that? Because normally the court does not concern itself with those types of developmental issues. But when you've got a man child, and you've got a man child that lives in an all-female household, and look at the geographical locations to where he is. He's in the Midwest, an agrarian area. He doesn't have a lot of friends. He doesn't have a lot of people to interface with, and certainly doesn't have any males who are positive role models that he can emulate. He is a young man child that has to be taken to manhood by a man. A woman is not a man. Your mothers are wonderful parents, and they do an excellent job as single parents, but a man child needs his father to take him to manhood. So the order is going to be based on a consideration of the desire of the 16-year-old, who can speak to the mediator, who can also speak to the judge, and do an affidavit that's notarized that tells the court what his expressed desires are. It could be by way of declaration, but an affidavit that's notarized is probably a little more compelling. Why is that? Because a notary is observing the child, seeing that the child is not under any type of undue influence, appears to be of sound judgment, is able to articulate what the paper says and what it is he understands that he's signing and what his wishes are. That document can then be incorporated into the OSC modification that is filed with the court. Yes, a minor's signature on a document, a legal document, can be notarized. The notary probably, for good order, should ask for some type of ID. If the minor doesn't have a driver's license yet, California DMV issues ID cards for any age of child, which can suffice for purposes of identification. Or if there's a witness, say a grandmother, who can be there at the time of the signing and can attest to the fact that, yes, this is my grandson, and yes, he's 16 years old. Those are the type of credible witnesses that can probably dispense with any type of card ID if the minor just happens at that point not to have that. But most kids around that age usually have some type of picture ID or student ID or whatever. Anyway, once those documents are filed, the court, the mediator, there's going to be a mediation because there's an issue of custody. And the mediator will then speak with the minor, and the minor will again articulate the fact that, yes, I want my father to tell me, how do I approach a young woman to go to the prom? How do I learn to date? How do I approach a woman to date? What are these hormones that are rushing? Why am I feeling this way? A lot of male children will not speak with women parents for obvious reasons. They're embarrassed. They don't want to do it. So at some point, they need their father to address those types of issues. Mom is probably going to be a little upset because there's a very real revenue stream that's being considered. But when you factor in the fact that you have a 16-year-old man child who is separate and apart from his father, those are very compelling considerations to both parents as well as to the court. And of course, the court will want to know about the father, so a supporting declaration from the father should suffice in this case to establish by way of written testimony and the penalty of perjury that all of the support has been paid, there are no arrears, that the father is gainfully employed, that he has a housing environment that can accommodate a 16-year-old male child, that there will be opportunities for them to spend time together. He's not a person that's away from the home, and the minor will be left to fend for him or herself. So these types of issues If they can be established to the satisfaction of the court, and the notarized affidavit of a 16-year-old male child who expressly says, I want my father to take me to manhood. I need my father right now. Those are very compelling considerations. And it's anticipated that there will be a positive result for the best interest of the child. And clearly, this is a changed circumstance as the child evolves into manhood and is away from his father because of the extensive distance. And hope that helps if you have an occasion to work on a family law matter. If you have any questions about it, feel free to contact me at teachblade@gmail.com. Thanks for listening. Have a great day. Bye-bye.